Assalamualaikum warahmatullahi wabarakatuh. My name is Nadiah Binti Bayani. My metric number is 1200671. For my individual assignment, I will present about transfer of title under Sales of Goods Act 1957. So first of all, objectives of the topic. First is to clarify the provision for transfer of title under the Sales of Goods Act 1957. And then to identify the effects of the transfer title under contract sales of goods between seller and buyer. And last one is to list out the exception of the rules in the Sales of Goods Act 1957. Applicable laws. Sales of Goods Act 1957, also known as SOGAR 1957, applies in Malaysia except for Penang, Malacca, Sabah and Sarawak. This is stated in the Section 1 of the Sale of Goods Act 1957 that the Act shall have effect within Malay states only. Therefore, Penang, Malacca, Sabah and Sarawak were governed by the English Sales of Goods Act 1893. The provisions of the Contract Act 1950 will apply to all contracts for the sales of goods unless they are inconsistent with the express provisions of the Sale of Goods Act 1957. Discussions of the legal principle. Under transfer of title, the fundamental rule is that no one can give what he does not have. It means simply that person having no title to the goods cannot pass a good title to another. Thus, if goods are bought from a person who is not an owner or who does not sell under owner's authority, the buyer does not acquire any title. Therefore, the rightful owner has the right to recover the goods from the one with no title. Transfer of title is important to protect a right of ownership. Even if the good is stolen, the owner still has the right to acquire the goods back. This is equivalent to the Section 27 from the Act, which already stated that goods sold by a person who is not the owner and who does not sell them under the authority or with the owner's consent, the buyer acquires no better title to the goods. The rule in Section 27 was derived from the maxim of nemo dat quod non habet, which means no one can transfer a better title than he himself. Now let's proceed with an example of case. This is in between Lim Chun Lai against Zeno Ltd. Facts: Zeno made agreement with a contractor named Ahmad. Ahmad had a contract with Petaling Jaya Authority for construction of culvert. Agreed that Zeno to provide all construction materials. Zeno then bought materials and delivered it to construction site. But at that time, the contract between Ahmad and Petaling Jaya Authority was terminated. Zeno then informed Petaling Jaya Authority that the materials belonged to them and they wanted to sell them. But at the end of the day, they found out that the materials already been sold by Ahmad. So held for the case is that Ahmad was just a bailee and not owner of the goods. Because he has no title to the goods and has no authority to sell the goods, therefore, the title of the goods did not pass to him. Moving on to the exceptions to the rule of nemo dat quod non habet. In these exceptions, buyer will acquire good title although the seller has no title to the goods. But buyer must prove first that he buys them for value in a good faith and without notice that the seller actually has no title to the goods. So these are the exceptions of the rule. The first one is estoppel. Estoppel is where the owner, by his conduct, makes it appear to the buyer that the person who sells the good has his authority to do so, and the buyer relies on that conduct and obtain a good title because the owner is precluded by his conduct from denying the seller's authority to sell. Next one is mercantile agent. Mercantile agent is where, with the consent of the owner in possession of the goods or of a document of title to the goods, any sale made by him when acting in the ordinary course of business of a mercantile agent shall be as valid as if he were expressly authorized by the owner of the goods to make the same. The third one is sale by one of joint owners. If one of several joint owners has the sole possession of them by permission of the co-owners, the property in the goods is transferred to any person who buys them from such joint owner in good faith and has not at the time of the contract of sale noticed that the seller actually has no authority to sell. The next one is sale under avoidable title. When the seller of goods obtains possession of the goods under a contract, but the contract is not rescinded at the time of the sale, the buyer acquires good title to the goods if he buys them in good faith and without knowledge that the seller actually has a defect for the title. Number 5 is sale by a seller in possession after sale. If a seller resells goods already supplied to a first client to a second buyer, the second buyer will get clear ownership to the goods if he accepts them in good faith and is unaware of the previous transaction. Then the last one is sale by a buyer in possession. If a buyer obtains possession of goods or title documents with the seller's approval after purchasing or agreeing to purchase goods, he may impart a good title to a future buyer acting in good faith, even if he did not get a good title in the first transaction. To summarize things up, transfer of title under the Sale of Goods Act 1957 clearly stated that nobody can decide to give out something he doesn't have. If things are purchased from a person who is not an owner and does not sell the item under the right permission of the owner, the buyer therefore does not obtain any title. Thus, the rightful owner for the item has the right to recover the things from the person who has no title to them. Although the seller has no title to the items, the buyer still will gain good if and only if he buys them for value in a good faith and without warning that the seller actually lacks title. Therefore, in my opinion, it is important for buyer to acknowledge at least the ownership information for anything they are going to acquire. This is vital to avoid any problems related to transfer of title ahead. That is the end for my presentation regarding transfer of title under Sales of Goods Act 1957. Thank you.